Hello, I'm Reilly Morse. I'm the General Counsel of the Mississippi Center for Justice, and today I'm going to provide you with an overview, trends, and some practice tips on the doctrine of environmental justice. This concept's basic principle is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. And it's rooted in the fundamental promise of American law to administer equal justice under law that's carved into the facade of the Supreme Court of the United States. It also is a application of civil rights era equal protection concepts to the realm of environmental law, the public health and public safety aspects in particular. Its origins stem from a movement that emerged in what's referred to as the Black Belt, a stretch of region that spans central Mississippi east through Alabama, Georgia, and the Carolinas, that over generations has traditionally had a higher concentration of African American residential communities. It's also traditionally been rural, and it's traditionally been low income. And over time, particularly starting in the Jim Crow era, but continuing on since then, white political leaders, regulators, and developers combined to select sites adjacent to these African American communities for the location of landfills and hazardous waste facilities. And a voice of protest arose from this region due to this discriminatory practice, and grew and swelled and eventually attracted the attention of federal authorities, which prompted a study by the U.S. Government Accounting Office to determine if there was a correlation between the siting of hazardous waste landfills and the racial and economic status of the surrounding communities. So let's take a look at that study. It looks at, among other things, sites located on the border between Alabama and Mississippi, South Carolina, and North Carolina. And in each instance, you see a high percentage of African American population in the census area of the site, as well as a high percentage compared to the statewide percentage of African Americans, sometimes by a factor of 2 or 3. This doctrine's development as a social movement, spreading out nationally and coming to embrace a variety of manifestations of environmental injustice in the American regulatory and markets, and in the dislocations caused by global trade, gathered together a lot of advocates under a lot of different themes and movements. And its first very large gathering occurred at an event hosted by the United Church of Christ in Washington, D.C. in 1991, titled the National People of Color Environmental Leadership Summit. And there was another one 11 years later. And while the reports and analyses and manifestos that came out of that are very interesting reading, the important point for this presentation is that it occurred in Washington, D.C. and was high profile and attracted the attention of the White House. So 2 years later, President Clinton issued an executive order, 12-898, commanding every federal agency to make achieving environmental justice part of its mission and to address disproportionately high and adverse human health or environmental effects of its programs, policies, and activities on minority populations and low-income populations in the U.S. It's worth noting that American equal protection case law has developed to focus upon what was referred to as discrete and insular minorities, and that included racial minorities, ethnic minorities, religious minorities, but it had not extended to low-income populations. So this environmental justice executive order goes further than the traditional case law has done in that area, for a very good reason, because it's clear that poor people generally tend to be targeted for environmentally unsafe sites. But an environmental justice executive order is not enough to keep you in court. You have to turn to the traditional tools of civil rights, equal justice enforcement, and those tools focus upon discriminatory intent or purposeful discrimination proved in one form or another. In the early cases in this area, of which these are examples, tended to conclude that while there might be some evidence of racial discrimination in the pattern or practice that's occurred here, that there was no proof that in this particular instance that was the primary motive for the decision, and that other factors relating to environmental suitability, not race, were the explanation for the decision. So with all that said, it seems like proving an environmental justice case where you have to prove purposeful discrimination would be difficult, if not impossible. And that's pretty much true, but not always.
Well, I was asked to attend a meeting, and they asked me what I thought of people that were opposing shopping centers in the most prime location in our city. And I referred to obstructionists as dumb bastards.
We didn't raise dumb children, and we are not dumb ourselves. And if your tongue cannot be handled any better than that, you have no place in public office.
So this was one of the first environmental justice cases that I personally was involved in as an attorney representing organizations and individuals. And it was on behalf of the Turkey Creek community, and upstream from the Turkey Creek community was a developer backed by the mayor who wanted to fill in hundreds of acres of wetlands that would have dramatically worsened the existing flooding problems on the creek and also worsened the water quality on the creek. As a result of these outrageous, inflammatory slurs by the mayor, however, the developer at that time chose to withdraw his permit and choose to fight again on another day. So in this instance, in this particular case, where you have such a clear-cut expression of racial disdain, the environmental justice argument won the day. But the more common pattern in this era, the 1990s and the early 2000s, was to prove the case through statistical analysis and historical patterns that clustered up and showed a overwhelming tendency, an overwhelming bias in the decision-making process. And in both of these cases, in Pennsylvania and in New Jersey, that's what the evidence was. That was what the evidence alleged. And in the New Jersey case, that's what the trial showed, and the court awarded that relief. That case was appealed, and it was reversed for a reason which I'll explain in just a moment. As with every sort of new trend in the legal world, there is inevitably a undertow and a swinging of the pendulum away from the trend. And so in this case, that occurred with a U.S. Supreme Court case which held that private parties do not have the right to enforce disparate treatment regulations under the civil rights law. So this was a categorical barrier for the kind of cases that were described in the previous slide. And it arose not in an environmental justice setting, but it applied to environmental justice cases as well as a wide variety of other kind of private rights of action. What this meant was that private parties no longer could act as private attorneys general. Instead, they had to get the agencies charged with enforcement of the law or the attorney general to take action. Well, the problem there was that the agency responsible for environmental protection itself had a poor record since the adoption of the Clinton-era Environmental Justice Command, and it had found no discrimination in any of the claims that had been filed. It had failed to identify minority and low-income communities or define key terms, and had not performed reviews required by the executive order. And in 2005, the EPA even proposed to drop race as a factor for identifying disadvantaged populations, which is extraordinary given the history that gave rise to this doctrine. But as the pendulum swings one way, so it will swing back in the opposite direction. And starting in 2009, environmental justice trend was revitalized and expanded under the Obama administration. There were medium and long-range plans promulgated, including Plan EJ 2014, and there was a very robust effort to get every cabinet agency to address environmental justice and to provide resources to build community capacity and expand science capacity to look at racial and poverty-based disparities in environmental protection, including the two at the bottom of this slide on exposure to chemicals and air pollution. Another tool that came from this expanded support for environmental justice was a citizens screen mapping tool that enabled ordinary citizens to be able to identify the clusters in their backyard of things like toxic release sites, Superfund permits, brownfields, and air and water permit issues, things which practitioners in environmental law and regulators have access to themselves, but this is putting that same set of tools in the hands of ordinary citizens. And yet again, this pendulum swings back in the opposite direction from before, and under the current administration, environmental justice is highly disfavored, and in 2018 the proposal was to zero out all EPA environmental justice programs, and while it did not completely zero them out, they were significantly curtailed with diminished staff and resources. And at a structural level, the current administration has proposed reforms to the National Environmental Policy Act that would dramatically narrow the scope of the focus of environmental impact statements and environmental assessments, which is one of the important places where environmental justice issues can be raised. There's a great many ways in which that happened. I've just identified two here, which is that it would eliminate the analysis of indirect or cumulative impacts, as well as consideration of whether project effects are highly controversial. There are others that relate to how many different kinds of alternatives have to be considered, and other issues that constrain the extent of the analysis. All of these things adversely affect environmental justice arguments, but they also adversely affect climate change matters. So to the extent those two coincide or overlap, it's a double whammy. Now I'm going to shift gears from sort of an overview of the history of how the environmental justice concept has evolved over time and talk more generally about how agency decisions relating to permits are assessed, and particularly at the level of a court. So if you're at all experienced in the realm of administrative law, you'll recognize readily that the judicial review of agency decisions like those that pertain to environmental justice give strong presumptions in favor of upholding the agency decision due to its technical expertise, and limit the situations in which courts can set aside the agency findings to situations where the agency has acted arbitrarily, capriciously, committed an abuse of discretion, or acted not in accordance with the law. Courts also in this setting are operating as appellate courts. They are bound by the administrative record by and large. There are some ways to expand that record, but we don't have time today to go into those. When you're looking at an environmental justice analysis, the type of things you'll be wanting to look for are, of course, the racial and poverty demographics of the affected communities. And you want to make sure that the community that's being analyzed is, in fact, the community that's being affected. That may seem self-evident, but as you'll see in a minute, that doesn't always happen. You'll also look for what is in the community history, and sometimes these histories will have to be taken from non-standard textbooks and from oral histories or other forms of documentation that are specific to low-income communities or communities that have not been adequately treated in the mainstream status quo and white-authored history books. You'll want to look into whether the analysis looks at past examples of discrimination against this community and whether there are important civil rights or Civil War era sites that that would be affected by this proposed action. And then, of course, you certainly want to use that mapping tool and determine if there are clusters of locally undesirable land uses. When you're trying to assess whether the decision can be upheld or whether it's vulnerable to being reversed, the kind of questions you ask are whether the agency failed or refused to consider a known impact, whether it made conclusory statements unsupported by the record, and whether it drew a conclusion contradicted by all the available evidence. So to help make this a little more concrete, we're going to use an example that's drawn from another matter that I handled, but we're just going to look at the fact pattern and not the actual case. So here we're going to look at a proposal by the State Port of Gulfport to fill in some wetlands acreage to enable the port's capacity to handle increased cargo to grow, and that cargo has to get off the port onto rail and onto a proposed expressway that would snake through and divide a majority African American community. So here's the entirety of the environmental justice analysis from that report, and it says that the port is located in Census Tract 14, that the census tract has a lower than average African American population and an about average mean income level, and ergo it is not an environmental justice community where the impacts would have any adverse effects under that doctrine. Well, the problem with that analysis is that it did not take into account the railroad where the traffic, where the cargo would be removed, or the connector road where other parts of the cargo would be removed, or the siting of an inland port where multimodal transactions would occur between the rail and the truck, all of which would concentrate diesel along those corridors. And diesel produces particulate emissions that have a localized adverse effect and lead to things like worsening asthma and other health pulmonary problems. So none of that's included in Census Tract 14, which spreads eastward from the port along the beach and is the widest and wealthiest part of my hometown of Gulfport. Instead, where they should have looked is the 4 census tracts along the contact path of the truck and rail routes, each of which has between a 40 and 80% African American population and a significantly higher than average poverty rate. So those are all environmental justice communities, and the effects of this proposed expansion were not taken into account. So that's where we turn back to these same questions, and with all that in mind, you can see how those questions end up getting answered. This is just an oversimplified version of what ends up being a much more complex story, and I'll be happy to share more information with you about it if you want to get in touch with me. Thanks very much for your time and interest, and I appreciate it very much. Bye-bye.